talk about marijuana some more.
The best committee ever.
Whoop, whoop.
We're live.
Good afternoon. This is the House Judiciary Committee. It is March 11th, 2021, and about 3 o'clock, and we're going to have a voting session. We are going to start with House Bill 270. House Bill 270, I don't believe, Lauren, are you on the, yeah, Lauren's here. I don't believe there are amendments to House Bill 270.
I'm sorry, there are amendments.
Oh, there are amendments. Can we show the amendments? Yes, we can. Can you talk about what the amendments do, Lauren? Or wait.
Sure, okay.
Was this, did you do this, David?
Sure.
Yeah.
Yes, either way.
Go ahead.
Okay, it's a simple bill. It was just intended to give a complainant in a sex assault case, if the case is not going to proceed, to give them an opportunity to hear why. And so it got worked out between the state's attorneys and advocates. And so the amendment increases the amount of time for that meeting or a conversation to have to take place from 10 days to 20 days. And makes the time, manner, and place of all this mutually agreed upon by the parties. And I don't think there's any opposition with that. So I would move the amendment.
There's a motion on the amendment. Is there a second?
Second.
And a second. Any discussion on the amendments at all? Seeing none. Can we see everybody? There we go. All in favor of the subcommittee's amendments, please raise your hand. Delegates Davis, Lopez, Cox, the vice chair, Jones, Bartlett, everybody's got one now. Griffith, Cham, Shetty, Williams, Conaway, McComas, Crutchfield, Cardin, Grammer, Erican, Moon. Anybody opposed? Seeing none, the amendments are adopted. We're on the bill as amended. Is there a motion on the bill as amended?
Move favorable.
Motion for a
Second.
favorable and a second. All right. Any further discussion on House Bill 270? Seeing none, we'll go ahead with a roll call. The vice chair,
Yes.
Delegate Erican,
Yes.
Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conaway,
Yes.
Delegate Cox,
Yes.
Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanita Fisher. Is not here. Delegate Grammer,
Yes.
Delegate Griffith,
Yes.
Delegate Rachel Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
Yes.
Delegate McComas,
Yes.
Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
Yes.
Delegate Ron Watson,
Yes.
Delegate Williams.
Yes.
All right, that'll do. I think that's 19. All right, one. The next bill on the list is House Bill 505. Lauren, can you tell me if there are amendments? I don't.
Yes, there are two
Are.
separate amendments that are being offered by Delegate DeMay. Okay, so this first amendment, it is authorizing the court to articulate certain findings of fact in a written opinion as an alternative to the requirement in the bill that the court articulate its findings on the record.
Is there, did you say there is a second amendment or is it just this one?
Yes, that's the first one, and then there's an additional.
Okay. What is the other amendments?
The other one, I think Dylan will put it up in a second, but it is striking language requiring the court to articulate on the record the weight that the court gave to certain factors in determining what legal decision-making authority and parenting time is in the best interest of the child.
Is there a motion on these amendments? Delegate Carden.
I'll move favorable on the amendments. I just wanted to ask a quick question to Lauren, though.
Second.
All right, well, there's a motion and second on these amendments, and then we'll have discussion. So that's fine. Now ask your question.
Thank you, Mr. Chair. On that second amendment, are they not required to express the weight at all, or they just don't have to do it in person? But they can instead do it on the record? I mean, on the in a written opinion.
So I think in answer to your question, combining those amendments, now the bill would provide that the court must articulate its findings of fact on the record or in a written opinion, including the consideration of each factor that is in the bill.
Excellent.
And okay, does that explain?
Excellent. That's exactly what I wanted to hear. Thank you.
Okay.
All right. Are there other questions? Other questions or any other questions about the amendment? Seeing none, all in favor of the amendment, please raise your hands. Delegates Davis, Lopez, Cox, Atterbury, Jones, Bartlett, Watson, Griffith, Malone, Shetty, Williams, Conaway, McComas, Crutchfield, Carden, Grammer, Arakan, Moon, and Fisher and Cham. There are just no one in opposition. The amendment is adopted. Go on the bill as amended. Is there a motion?
Yes, there's a motion.
Second.
Motion and a second. Any further discussion on the bill? Delegate McComas,
Mr. Chair,
you went mute. Try again.
Okay, one question, because we have so many people going in on these custody cases that are pro se, I assume that we have the access to justice or whatever. Do they, in other words, do the advocates who help these folks that are pro se, they think this is going to really help? Because a lot of times people walk out and they don't know what happened and they're just kind of like in a fog. And so I think if everything's explained, this is going to be better for the system.
I think that's the argument, that the putting everything on the record and putting everything in a way that people can understand why the judge decided the way they did, I think is part of the big goal here. And by laying out the different sort of fact points that are required, I think that's kind of the bigger picture and should make it a little bit easier for people to navigate the system, I believe. But I'm happy to hear from other people.
Well, the only comment I would make is a lot of times, although she has it both ways, you know, either it's written or a written opinion or it's an oral opinion. I'm thinking if the judge could just, I mean, a lot of these people couldn't afford to get a transcript of the decision. And so I think, I'm not going to argue it. This is really moving forward, but some people that are pro se, maybe if there's some way that, they could provide them with some kind of a written record of it would be good too. Just, if both parties are pro se, at least to start it. And then maybe if one party's pro se, have it taken down, but that's for another day.
All right.
For money. So it's
All
all.
right, I see Delegate Arakan, then Malone, then Davis. Delegate Eric.
I was just going to ask if this was part of the work group bill, but it is. So I like it.
Delegate Malone.
My concern with requiring a written opinion is it is not unusual for judges to be very slow in issuing their opinions. I have a trial that I had on January 8th and I'm still waiting, and justice delayed is sometimes worse than justice delivered. And if you start making judges issue written opinions, you might sometimes been waiting a long time. It shouldn't be the case, but that's reality.
So again, I think with the amendment, it's an or.
I agree. I'm just speaking to Susan's comments.
I got it. Go ahead.
Yeah,
Delegate McComas.
Okay, and what I was is that if somehow somebody could, they would be a way that the transcript of the judge's opinion that he gave orally from the bench could be transcribed so that both parties would have it, so that, because, you know, if they're pro se, they obviously don't have a lot of money, and we're helping everybody else. But a lot of times the courts take up a lot. Custody and visitation cases can chew a lot of time, and you get all this ex parte stuff and motions for contempt. And I think if they could see it in black and white somehow, you know, I'm not saying that the judge should have to write a written opinion. I understand that they take too much time, but if some way there could be some kind of deal cut where, you know, they could get a discount rate or whatever, I think it would create some more peace in the kingdom. That's all.
Delegate Deborah Davis, please.
Thank you, Mr. Chair. I guess my question is for legal. The Office of Public Defender had some concerns about excluding this language from application to center cases. Do any of the amendments deal with that?
Lauren?
They do not deal with that, and I did follow up on that concern with Delegate Dumais, and we did check with a judge on the who served on the commission just to double check. But my thought, and the judge's thought as well, was that that's not necessary because the CINA provisions are in a totally different part of the code. They're in the Courts and Judicial Proceedings Article 3-8A subtitle. So it would not be necessary to keep putting into the other parts of the code that it doesn't apply to CINA cases. It just doesn't, because it's not related to that part of the code dealing with children in need of assistance.
Thank you.
Sure.
Are there further questions? All right, seeing none. We adopted the amendments yet? Let's adopt the amendments. No, did we do that on this one? Yes, we did that already on this one. So we adopted the amendments. We're on the bill as amended. There's a motion for a favorable. We're ready for a roll call. The Vice Chair?
Yes.
Erican?
Yes.
Bartlett?
Yes.
Hardin?
Yes,
Pardon?
yes.
Conaway?
Yes.
Cox?
No.
Crutchfield?
Yes.
Deborah Davis?
Yes.
Juanika Fisher?
Yes.
Grammer?
Yes.
Griffith?
Yes.
Rachel Jones?
Yes.
Lopez?
Yes.
Malone?
Yes.
McComas?
Yes.
Moon? Moon?
Yes.
Shetty?
Yes.
Sham?
Yes.
Ron Watson?
Yes, sir.
Williams?
Yes.
All right. 19-1. Right. Okay. 646. This came out, I think, of the Family and Juvenile Subcommittee, I believe. Delegate Crutchfield, is that right?
Correct.
All right, are there any amendments? I don't see any.
No, there are no amendments.
All
No.
right. All right. Is there a motion on the bill?
Move favorable.
Motion for
Second.
favorable in a second. All right. Is there any discussion on the bill? Seems like it makes that necessary connection with the program there for DoD. And that seems to make a lot of sense to me. Anybody else have any comments or questions?
I'm sorry, what's the bill number?
The bill number is 646. Delegate Cardin,
I'm trying to read the bill. It requires there to be an MOU between local Department of Social Services and the military's, I guess, analogous organization. What if one part, I mean, so we're not giving them the choice if they don't want to, they feel as if they don't want to participate? I'm just curious.
Well, no, we're not. So it is requiring them to do that because oftentimes, the two different entities don't know what's happening. So you've got things happening, in the military world, things are a little different, obviously. So they want to understand if there's something else going outside of that environment that they should be aware of that's affecting that military family. So that's really what this is about, just making sure everybody is lined up correctly. But you're
Is there one entity that is just not, the local jurisdiction doesn't really want to be involved with the military? Or is it the military that doesn't want to be involved with the local, or is it both?
No, I think the problem is that there just isn't that connection. It's not that the outside state entity doesn't want to be involved. It's just that there's never been a requirement that they do it. And it's important that all the different, linkages work together so that each knows what's happening. And specifically, more or less, it's really more on the military side. They really do want to know and understand what's going on with military families. If there's an issue with abuse or anything else, they need to know that. So that's pretty critical. So.
Okay. And does, just last question, do all military installations have some sort of military advocacy program?
Most of them do. I don't know about all, but most of them do. If they're military installation, like the bigger bases, I'll put it like that, usually do have some kind of military,
Okay.
like a family practice area or a family, yeah.
I think the ones that we have in Maryland, I mean, we have a lot of larger ones. We don't have
Correct.
a lot of smaller ones. So, I mean, APG, Fort Meade,
Mhm.
maybe Fort Detrick, and
Yeah, even Walter Reed
Pax
is
River.
considered one.
Andrews, yeah.
yeah. Andrews. Oh my goodness, Andrews.
Yes.
Delegate Williams.
Yeah, no, I was just going to add that under, according to the DOD's testimony, that they are required under federal law. It says each military installation or unit with 500 or more personnel must establish a family advocacy program. And so they enter into the MOUs to help them be in compliance with their federal statute that they have to be in compliance with under their family advocacy program. And so that's the necessity, I guess, for doing the MOUs to make sure that all of the military installations are in compliance with that.
Right, Delegate Shetty.
Thank you, Mr. Chair. Madam Chair of the subcommittee, could you please remind me what the subcommittee vote was?
I will have to look for it unless.
I thought I remember it being
Lauren
unanimous.
has
I think it was unanimous.
I think
thought
it was unanimous.
too, but I wanted
I
to
think so.
verify that.
Yeah, I just remember vaguely that there was not a lot of controversy.
Yeah, there wasn't. There really
Thank
wasn't.
you.
Lauren, do you happen to have that handy?
I don't, but that's my recollection. I think that's why I didn't write it down.
Okay. All right.
I'll move favorable.
As a favorable, I think, is there a second? We already.
Second.
All right. I don't think we need any more discussion. We'll go to a roll call. The Vice Chair,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Sham,
Yes.
Watson,
Yes.
Williams.
Yes.
That's 20. Okay. I have just a quick question about this next bill. Do we all have quick questions about this next bill? It's Delegate McComas's bill. Does anybody else have a quick question about this, Phil? I love you,
I
Delegate.
want to know about the unintended consequences.
Me too.
All right, we've roasted Delegate McComas sufficiently. That's enough. That's
I want to know
Can
about
she
those
explain?
Baltimore City people.
oh.
Who's got a hold left?
Who you calling you people?
Well, I started it, so it's my fault. House Bill 701, Delegate McComas. We passed this bill last year, and I think we passed it unanimously last year.
Move favorable.
Motion for a favorable. I don't believe there are any amendments. There are no amendments. Okay.
Second.
And there's a second. Any further discussion? All right. The Vice Chair,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
C.
Grammar,
C.
Griffith,
Fine.
give her a complex. All right, Delegate Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
I do love you, McComas. Are you thinking about it?
Oh, no. Look at,
Wait, did you just vote no?
no, I didn't. No, just, you know
You
what?
just voted no 14 times.
No. Yes.
Is
Oh.
your final answer?
Yes.
Shetty,
I'm sorry, who did you vote? Ask now? Me?
yes.
Oh, yes.
Cam,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
All right, 20. There we go. Oh dear. All right, 748, the Vice Chair's bill. I believe there are amendments.
That's right.
All right, can we put them up, please? And who wants to say what the amendments do? Do we want the Vice Chair, or Vice Chair, do you want Lauren?
Yes, please, Lauren.
All right.
Sure. The first amendment is just technical, and the second amendment is striking the language in the bill relating to factors for courts to consider in custody and visitation proceedings. And the rationale is that this subject was just covered in House Bill 505 that you just gave a favorable report to.
Okay, so it just takes out the part that was in Dumay's bill. Okay. All right. Is there a motion on the amendment?
Move the amendment.
All right, in a second.
Second.
Great. All right, motion and a second. Any discussion? Delegate Cox. Then Eric.
Thank you. So for council, did that also strike the part where it was, let me get the line here, where there's no presumption? Because I know there was differing language in the two bills on that.
That's right. It took out, if you're thinking about the presumption on joint custody, that's,
Joint custody presumption, right?
yes, that's stricken from the bill
Oh, okay.
by this amendment.
So what does the bill do now?
So now the two main things is it's revising the language dealing with the provisions of law that require courts to deny custody or visitation rights to parties where abuse or neglect is an issue. And I would say the two main changes are that the court now needs to state with specificity the reasons for a finding and take into account the specific type of child abuse or neglect, including whether it was emotional, physical, or sexual. So it's sort of just tweaking that language that's in current law that you'll see on page 2 of the bill, starting at line 10. It's just kind of making those slight revisions. And then another change that's left in the bill that's a new provision would be that this is dealing with denial of visitation or interference with visitation. And it's saying that any reasonable effort to protect a child or a party to a custody or visitation order from the other party may not be considered an unjustifiable denial or interference.
That's-
Nothing new.
That's without an application for a court order for that? That's just on their own?
What do you mean, Delegate Cox? What do you mean?
I'm sorry, there's a truck going by my window. So any reasonable effort would be a party just deciding not to follow the court order because of the concern
So,
that party has, rather than applying for the court order first before denial?
correct. So
Okay.
if somebody went to court and said the other party denied them visitation and the other party's defense, they could show that they were making a reasonable effort to protect the child from abuse, then their denial of visitation won't be considered unjustifiable, but they would have to show that.
They don't have to tell the court about it first.
No.
Okay. Okay, thank you.
Delegate Arakan?
So is this is the one that touched on the parental alienation issue in the, is that the same bill?
Yes.
So is that part taken out of this now? So people can still use parental alienation as a offense with this new amendment?
So I think the part that Delegate Cox was just talking about in I think that's page 3, line 21. C. So the issue was mostly mothers. I'm just going to say mothers were going to court alleging abuse, and the judge, and then the other party would just say, no, you're just making that up. You're just trying to alienate me from my kids. And the statistics showed, quite frankly, that the kids were being given visitation with the abusive parent, and the mothers were not being believed. So this provision says that if the mother denies that visitation, then I guess the parent could still argue parental alienation, but the mother's not going to be penalized if she can show that she reasonably thought that parent was going to abuse the kid. So she's just like, I'm not going to send the kid back to being abused, because now that's the only choice, really.
Okay, that helps clarify that. Thank you very much.
Thank you.
Are there further questions? Seeing no further, Delegate Rika Fisher, please, for on the amendment.
Oh, no, I wanted to move the amendment.
All right, motion on the amendment is
Second.
second. All right, I think we already did that, but we'll take the vote on the amendment. All in favor of the amendment, please raise your hands. Delegates Shetty, Williams, Davis, Malone, Cham, Atterbury, Cox, Lopez, Arakan, Griffith, Watson, Bartlett, Conaway, Crutchfield, Cardin, Grammer, Moon, McComas, and Fisher. Any opposed? Seeing none opposed, the amendments are adopted. We are on the bill as amended. Is there further discussion on the bill as amended?
Move favorable.
Motion for
Second.
favorable, Delegate Cardin, and there's a second, Delegate Cardin with the question.
Yeah,
Delegate Cardin.
I'm seconding. I just want to say, so according to the testimony, it looks like the only unfavorable in this were the judiciary and Mr. McElvoy. That's
Well, both of them oppose everything, so.
right. But we basically got everybody else together on this. This wasn't, so the judiciary wasn't arguing the alienation issue. So I think that was a different bill, because there was a bunch of people arguing alienation on it.
So both of these came out of that work group. That was the bill related to training of the judges on child abuse and sex abuse that they
I
don't.
look forward to voting for this bill.
Thank you.
Are there any further questions? Delegate Cox?
Thank you. I mean, I would love to be able to vote for the bill because I think that it's addressing, the vice chair is trying to address something that's a serious need to tighten up in the law, but I think I'm going to have to vote against it because it does bind a judge in the context of issuing orders. I think it probably could be fixed maybe with notifying the courts and not disobeying an order. That would be my main concern there, unless there was some exigent circumstance, maybe. Because otherwise, right now, you're going to have, the way it's written is, you're going to have a party who believes that it's a reasonable effort to protect themselves because, I don't know, they had an argument and they're fearful, so they just simply don't show up to the child custody transfer. And that could be every single case.
May I respond, Mr. Chair?
Yes, the vice chair.
Thank you. So, I mean, I hear your concern. I think that if they don't show up to the custody exchange, that would be sorted out in court and that they would have to show that why they did that. And the judge would have to make a determination. And if they were deemed to, the judge didn't believe them, then they would be penalized accordingly somehow. I mean, certainly I think it would be more problematic if they then did not show up to the court hearing. But I think if you deny visitation because you have a belief that someone is abusing your child, then you have to go to court and prove that. But I hear you're saying that it could be abused. I hear that.
Delegate Cardin, do you have a further question or did you just forget to take off your hand? All right. Are there further questions, comments? Seeing none, we will go to a roll call on the bill as amended. The vice chair,
Yes.
Delegate Arakan,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
No.
Juanita Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
Thomas.
Oh,
No, okay. Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
No.
Williams,
Yes.
15-5. Motion passes. Okay, we have two more. And then another. Let's look at House Bill 870. Oh boy. All right, so this is coming out of civil law, correct? So this is Delegate Cardin and Holly. It appears there are amendments. Can you tell us what the amendments do?
Holly, do you want to go or do you want me to go? It's up to you.
No, that's fine. I can start and you can take over. So these are sponsor amendments and they were introduced not only by the sponsor when she introduced her legislation, but they're elder law and estates and trust amendments. The majority are just clarifying, and all they do is they change the existing Maryland limited power of attorney, the general and the short forms, to allow agents to apply for governmental benefits and programs. So currently, the forms do not allow for that option. So the agent would not be able to necessarily act for public or governmental benefits like Medicaid, for example. And that's all these amendments do, is just clarify what options are available on the short and the long forms.
Okay.
That was the intent of the bill originally, and so the amendments needed to be to make sure that it was done properly.
Exactly. There were two sets, and this has been shown to the advocates, and everybody's on the same page.
I would move those amendments.
Motion for the amendments. Is there a second?
Second.
Moved and seconded. Let's go to the screen. All in favor, raise your hands. Delegates Cardin, Cox, Shetty, Williams, Atterbury, Lopez, Arakan, Davis, Cham, Griffith, Watson, Bartlett, Crutchfield, Grammer, Moon, McComas, Conaway, and Fisher. Anybody opposed? Seeing none, the amendments pass. Amendments are
Move favorable on the bill.
moved favorable on the bill. Is there a second?
Second.
Moved and seconded. Any further discussion? Seeing none. The vice chair,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes, sorry.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
That's 20. Okay, one more. And then we've got a couple withdrawals. House Bill 1266 has a questionable sponsor, Delegate Juanita Fisher. Are there amendments?
No.
I didn't see any amendments. Fine. There are no amendments to the bill. Can I have a motion?
Move
favorable.
Is it favorable in a second? I believe we got this for, yeah, I got it. Okay, any further questions or comments? This came out of the Civil Law Subcommittee, correct, Delegate Cardin? All right. That's fine.
I'm sorry, what's the bill
Yes,
number?
that's correct.
1266, Estates and Trusts, Custodianship of Wills.
This is basically don't burn your will.
Yeah.
Yeah,
Do you want me to say something about it, Mr. Chair?
go ahead.
Okay, thank you, Mr. Chair. Basically, this bill establishes some requirements and duties around storing a will. It allows you to actually deposit wills at a register of wills. The Register of Wills, if you all remember from the hearing, came in and said they were willing to actually take that on. And it provides sort of parameters and best practices. It doesn't force them to do it this way, but it does provide sort of a standard on how to store wills and to be able to drop off a will to be stored at the Register of Wills. It's obviously it became a huge issue during this last year, sadly, with the death of so many Marylanders. And the bill doesn't force them to do it this way, but it makes sort of a practice, and especially if you're like a law practice and you're ending, and it's like, where are you gonna put all these wills? You can actually put them at the Register of Wills. That's kind of like very briefly what the bill does.
And it gives guidance to lawyers and other people, but primarily lawyers, on how to how and when they're allowed to get rid of a will if they don't know whether the person's still alive or still interested in having the will, or whether the will is still in force.
All right, Delegate Arakan, then Griffith, then Conaway.
Thank you, Chair. I was actually just going to ask, I know Delegate Cox had some concerns about it during the hearing, and I'm wondering if any of those were cleared up or what his opinion was on this. If he doesn't mind. I don't know if he can hear us.
Could I respond, Mr. Chair?
Sure.
Oh, no, you're freezing, I think.
So I think my concerns were. Can you hear me?
Yeah, go ahead.
Yes.
Okay, yeah. I think my concerns were cleared up through the amendment committee process.
All right. Delegate Griffith.
Thank you, Mr. Chair. So Delegate Moon, do you believe this bill would clear up any shenanigans with people's wills?
Don't burn it. Don't burn it.
Delegate Conaway.
Yes, Mr. Chair, in reference to the shenanigans with wills.
Shenanigans.
My sister is a registered of wills in Baltimore, and one of the members here on the committee said I need to ask you if I need to pass, or is it okay for me to vote on this?
Not a conflict.
Is it a conflict or is it okay for me to vote?
Do you work in the, you don't work in the Register of Wills office. Your sister does? And yeah.
Yes, she is the registered of wills.
But you don't.
No, I don't.
I just
I
meant
don't
because you
think-
like to say pass, Conway.
I wasn't going to say that she's the one who said it, so I
I was roasting him for a pass he made last week.
Oh, okay. Thank you, Mr. Chairman.
No, don't give Frank a hard time. I think you're fine. I think so. I don't think that you personally benefit from legislation, nor
I
do I
don't.
think you
Well-
work, you don't work in that office, so fine.
I don't. No.
Okay.
But Mr. Chairman, even if he did work in the office, I don't think you have to pass on this because there's no conflict of interest in how this bill, what this bill does with Register of Wills. So
I don't think it does either. So, okay.
Thank you very much.
Now that we did that,
Move favorable.
there's a motion for a favorable.
Second,
And, all right, the vice chair,
yes.
Eric Han,
Yes.
Bartlett,
Yes.
Carden,
yes.
Conway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Fisher,
Yes, from one of your favorite sponsors.
Delegate Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson,
Yes.
Williams.
Yes.
Okay, thank you all very much. All right, there are two bills that were withdrawn. House Bill 263, which was Delegate Wilson's bill related to child sex abuse. We were going to have hearings today. We did not because he has withdrawn the bill. And then Delegate Grice had a House Bill 1164 that he has withdrawn as well. Can I have a motion, please? For an unfavorable?
Move unfavorable.
Is there a second?
Second.
All right, all those in favorable, all those in favor of the unfavorable withdrawn, please say aye.
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 Anybody opposed?
Me.
All right, Eric Han opposed and Grammer opposed. Okay,
I'm abstaining.
I understand.
I say pass.
Ditto.
And I abstain too.
All right, wait a minute. So if we're gonna do this, then I'm gonna call a roll call on the unfavorable, on the unfavorable withdrawn. So, and if it's for two.
Wait, what happens if it passes?
If you
It's an
abstain,
un-
it can't pass.
You can we separate them out?
All right, we're gonna
It would have
separate
to
them
be a new
out.
motion. Yeah.
All right, we're gonna separate them out. We're gonna, because if people have discomfort, I'm not gonna do that. We'll do House Bill 263. The sponsor has withdrawn the bill. And so I believe the motion is for an unfavorable withdrawn,
Second.
and there's a second. All right,
Do we
Can I
have,
ask a question?
okay, who would like to ask a question?
Me.
Eric can.
Thank you, sir. Can Claire or Holly just tell us if there's a lot of abstentions, if there's a lot of abstained votes, what happens to the bill? Can it still be moved unfavorable, or do we need a certain number of us to vote yes?
If it fails, it just stays in the drawer. If it fails, in this case, the sponsor of the bill has moved to withdraw the bill. So what would
Okay.
happen is on an unfavorable motion, I mean,
Okay, so
if an
so we will-
unfavorable motion fails, my policy that I said a long time ago that we haven't had to really revisit for years, but the policy would be theoretically, it could be brought back on a favorable. But being that the sponsor of the bill is withdrawing the bill,
Yeah.
I wouldn't do that. So,
I'll vote yes in the unfavorable.
all right, well, that's fine. But, all right, so here's what we're gonna do. Given that, I don't know if it's unreadiness or not, but we're gonna go ahead and we'll call a roll call. On the unfavorable withdrawn.
Delegate McComas, Mr. Chair.
Oh, there she is. Delegate McComas, please.
All right, Mr. Chair, I just want to know, do we know why he did that? Is it this, was it Senate action? Because I think it was I think it was cross-filed.
The Senate hasn't taken any action. I don't believe. I don't know that they're going to take any action. I don't want to ascribe anything to judicial proceedings in this matter. It's a very serious matter. I'm not making light of it. The sponsor has asked for it to be withdrawn for this year.
Okay.
And I don't believe that the issue is going anywhere. I believe the issue will come back in future years, to be sure.
Okay, I just wondered because I think the Catholic Conference had hired Bobby Zirkin to lobby against it. So that's what I'd heard through the grapevine. So.
All right.
I don't know. I mean, not that that's the reason, but I just wondered why he did that because I know he's been very passionate about the issue. So, yeah. All right.
So the motion is on an unfavorable. And we're going to take a roll call. The vice chair.
Let's do what you.
am going to abstain. That does not mean people have to do that. I believe that the sponsor of the bill has worked incredibly hard and gone through a lot of emotional trauma for the bill, but perhaps believe if his name was not on it, he could get it through with the Senate sponsor. I also think that he was very concerned about all of the people that came to testify in the years past being at home alone during COVID and calling in or Zooming in to testify and having to relive trauma on their own and not wanting people to have to experience that. So with that,
I believe that was conveyed to me too, and I will just say that was also a concern here. And you have explained your abstention. Delegate Arakan.
Yes.
Delegate Bartlett.
Yes.
Delegate Cardin.
Yes, on the unfavorable.
Delegate Conaway.
Yes.
Delegate Cox.
Yeah.
Delegate Crutchfield.
Yes.
Delegate Deborah Davis.
Yes.
Delegate Juanita Fisher.
I'd like to abstain.
Delegate Grammer.
No.
Delegate Griffith.
Yes.
Delegate Rachel Jones.
Yes.
Delegate Lopez.
Yes.
Delegate Malone.
Yes.
Delegate McComas.
Yes, yes.
Delegate Moon.
No, I don't think we have a sponsor problem either, and I'd like to see us take this thing up. I think there's a continuing course of conduct here. Sorry.
All right. Delegate Shetty.
No, for the same reasons. I'd like to be able to vote on this.
Delegate Sham.
Yes. You get that, Chairman?
Delegate Watson.
No.
Delegate Williams.
I'm a vote no.
$13 to 5, the motion for an unfavorable passes. All right, now let's try this again for Delegate Grice. Unless somebody wants a roll call for 1164 for an unfavorable withdrawn on 1164, all in favor of the unfavorable withdrawn, please raise your hands. We'll do that. Please raise your hands. McComas, Conaway, Griffith, Arakan, Davis, Williams, Shetty, Cox, Carden, Malone, Lopez, Atterbury, Cham, Watson, Crutchfield, Moon, Jones, Bartlett, and Fisher. Did not see Grammer's hand. All opposed, or you were for the unfavorable or the unfavorable withdrawn? Oh,
No, I'm opposed. Sorry for
you're
the.
opposed to the unfavorable. All right. Well, still the motion carries on the unfavorable withdrawn. Now, we've finally gotten to one last thing. On House Bill 52, could we please put this on the screen? I think this is kind of a technical amendment, but after thinking about it, and maybe thinking about it too long, I decided that I wanted to bring it before the committee because I think it's just over the line. In the notice requirement in House Bill 52, it requires that the notice include contact information for the Maryland Legal Services Corporation. They contacted the committee after the bill passed and said, well, it really shouldn't be us. It should be, and you can read here, the nonprofit legal service organizations that may provide legal advice or representation to the tenant as compiled by the Maryland Legal Services.
Move the amendment.
There's a motion. This would be a committee amendment on the floor.
Second.
Motion and a second. Any discussion? Delegate Griffith?
I apologize. Were we sent a copy of the amendment?
This is something that we got just recently, and so no, we didn't send it out. And I mean, honestly, I think this is right over the line of what would be a technical amendment, but I think it is. I thought it was substantive enough that I wanted to bring it to the committee to just at least make you aware and get sign off before offering it as a committee amendment.
Well, I don't want to hold the vote to get it, but could, while we're voting or immediately after the vote, could it be emailed to us, please?
Yeah, no problem at all. No problem.
Thank you.
And if people are getting amendments drafted, and if people are getting amendments drafted to that part of it, fine. Just please let me know, and I'll work with you for the floor debate. But I don't think it should be an issue. Okay, so on the amendment, motion and a second has been out there. I'm looking at everybody. All in favor of the amendment, please raise your hands. Delegates McComas, Conaway, Griffith, Arakan, Davis, Williams, Shetty, Cox, Carden, Malone, Lopez, Atterbury, Cham, Watson, Crutchfield, Grammer, Moon, Jones, Bartlett, and Fisher. That's everybody. All right. Thank you very much for indulging me with that. Just felt like it was the better thing to do. All right. We have floor at 5 o'clock. Thank you all very much. That concludes voting session for the House Judiciary Committee. We have a vote session still set for tomorrow and a possible voting session on Saturday to be determined. We will let you know as soon as we can. All right. It's that time of year. We'll do the best we can and for a Saturday voting session to try and schedule it at the best time that we can. Thank you all very much, and we'll see you on the floor.
When is a good time on Saturday? When would be a good?
There really isn't one, but thank you
Okay,
very much.
I just want to make sure that we were in agreement on that. Okay.